Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public. So please subscribe to our channel. Today I want to talk about the protection of assets during the divorce and what might be 3 or so ways of protecting those assets. Well, number 1, you've got to distinguish between assets that are marital and assets that were accumulated before the marriage. If you come to a lawyer and you say, then we've been married for 12 years, here's a list of assets, that lawyer is probably going to presume that those are the assets that relate to the 12-year marriage. Therefore, if you've got assets that were prior acquired before the marriage, number 1, you've got to spell those out to your lawyer. You've got to tell your lawyer when every single asset was acquired. Now, it may or may not make a difference depending on the evaluation, but number 1, very important to disclose to your lawyer which assets are prior acquired. Number 2, if you have prior acquired assets, it's very important to protect those assets by determining what was the value of those assets at the time of the marriage. If, let's say, you bought a house and you've had it before, maybe you inherited the house, and years before the marriage, and you move into the house, and then 10 years later, you're getting a divorce. What happens with that house? We're assuming that the house has never been gifted to the marriage, and that's a subject for another video. But assuming it's always stayed in your name, just like the day you got it, what's the value? We have to look at the value of that house as of the day you got married. Maybe it's worth $100,000 as of that day, but now maybe it's worth $150,000. So the calculation would be that the $100,000 that it was worth the day you got married, that's yours. Only the $50,000 is in dispute. $25,000 is hers. $25,000 is yours. So of that $150,000 value, you get 1 1/4 to her quarter. But you've got to determine the value. The second way to protect your asset is determine the value of the assets as of the time that you got married. And number 3, great way to protect your assets, don't hide them. Okay? A lot of people think the other way around. I'll protect my assets by hiding them. I won't tell my spouse what they are. He or she never knew anyway. I'll put this in someone else's name. I won't mention that I have another house somewhere. I won't mention this. Here's the problem with that theory, other than it being, completely dishonest to the process. A smart lawyer is going to figure out a way to find out about it. He's going to find it. And when you don't disclose it, he's going to go to the court, he's going to file a motion regarding that non-disclosure. And the penalties for non-disclosure are severe. The penalties for non-disclosure result in the court setting aside the divorce, reopening the discussion of the assets, and giving that asset that you tried to hide to the other person. And I don't mean splitting it. The court has the right and the discretion to take that asset and give most or all of it to the other person because of your non-disclosure as a penalty for not doing what you're supposed to do. So you want to preserve your assets? You got to make sure that you highlight all those assets. And believe me, it's much better to say, look, I have all of these assets, but these are prior acquired, and I'm arguing before the court that these are off the table. And you can do that. And the court will make determinations. But the moment you say, well, she's not entitled to it, and therefore I didn't include it, that's the moment that you risk losing that asset. Now, if you have any questions about your case, reach out, and we'll be glad to help you out.